Let's discuss with my political panel. Joining us, Laura Coates, CNN legal analyst, former federal prosecutor, Elise Labott, our CNN global affairs correspondent, David Gregory, CNN political analyst, and Gloria Borger, our chief political analyst. You can see the vice president sitting down, Stephen Miller, one of the top policy advisors to the president. Next to him, Steve Bannon is over there, Kellyanne Conway, names and people all of us, Gloria, have become pretty familiar with over these past many weeks.
For better or for worse. I mean, Kellyanne Conway had her own controversy yesterday about whether she was doing an advertisement for Ivanka Trump from White House property, which is, of course, another violation of ethics rules. And so, yes, the person I'm interested in sitting there, and I saw that the vice president shook General Flynn's hand, is the vice president, as David was pointing out, because he went out on a limb saying, and he must have been assured of that, saying that there were no discussions about sanctions. And when you put your own vice president out there on national television to say that, and his staff is trying to get to the bottom of it, is what we are told. I bet they are.
Yeah, it's a picture of some real turmoil.
Yeah, well, another question that almost certainly will come up, Laura, is the decision by the Ninth Circuit Court of Appeals last night to go ahead and tell the Trump administration, at least for now, that proposed travel ban you want, barring certain people from 7 Muslim majority countries from coming into the United States. You know what? That's not happening right now. They have to make a major decision, the Justice Department, the White House, what to do next legally.
They do, and this was a huge setback. It was a blow because they've now had a very, very strong defeat in the Ninth Circuit. And while there's been much ado whether it's a liberal-leaning circuit court or not, you did have bipartisan, essentially, support on the justice's behalf to say this is not an appropriate action to take, perhaps, at this time. But most importantly, they have checked executive power, and they have made their gavel particularly strong in saying democracy requires that we do question an executive order if it seems like it may violate the Constitution. This is pretty much unknown to somebody like Donald Trump, who is not expecting that level of checks and balances. But I think it was successful to show that democracy actually has a part and works.
It's a major setback as far, but he could come back, and I assume one of those reporters, American reporters, I'm not sure about the Japanese reporters, or American reporter, might ask him, what are you going to do next? Right. He could come back and simply say, well, we're going to throw out what we originally put forward and come up with a new plan.
Or they may read him his own tweet where he says, I'll see you in court, and ask him, which court did you mean? Because that's the big question on the table. He could go to a larger portion of the Ninth Circuit or the Supreme Court. But guess what? As of a year ago, we're down to 8 justices. And I think you're probably going to need 5 to secure a victory in this case.
I'm sure he's being counseled to pull it back.
Like Kellyanne Conway counseled?
And to review the executive order and to make it clearer and less broad. But the question is, he may be being advised to do that by some of his counsel.
But will he listen?
But will he listen? Because he never admits he made a mistake, ever.
But also,
so maybe he'll blame it on the judges, or he'll blame it on his attorneys at the Justice Department.
One of the things that was absent, and maybe this will come up again today, is what is the evidence behind why the executive order was needed? What is the specific threat that means that the United States has to move with such alacrity?
All right, they're being introduced right now. People are standing up. The Prime Minister of Japan, the President of the United States. They'll both have opening statements, beginning with the President.
I feel totally confident that we will have tremendous security for the people of the United States. We will be extreme vetting, which is a term that I developed early in my campaign because I saw what was happening. And while I've been president, which is just for a very short period of time, I've learned tremendous things that you could only learn, frankly, if you were in a certain position, namely president. And there are tremendous threats to our country. We will not allow that to happen. I can tell you that right now.
That's, at least in marked contrast to what the former Director of National Intelligence, James Clapper, told our Jim Sciutto only yesterday. Remember, today is 3 weeks exactly to the day since Donald Trump was inaugurated and became President of the United States. He said specifically there are tremendous threats to our country. We will not allow that to happen. Listen to what Clapper, General Clapper, told Jim Sciutto.
Does the terror threat necessitate the ban from these 7 countries?
Well,
I don't believe we, the IC, were aware of any extraordinary threats that we weren't already dealing with.
Does a ban like this, in your view, does it damage U.S. image, but also counter-terror partnership?
Yes, I do worry about those countries in question with whom we do deal and who are reliable partners.
Actually, until 3 weeks ago, he was the director of national intelligence, for about 6.5 years, privy to the most sensitive intelligence information, the most highly classified intelligence information. He offers a pretty different assessment than what President Trump just offered.
And he said you only are president to have this type of information. Well, several weeks ago, President Obama was the president, getting that daily press briefing of the threats, and one would assume that his director of national intelligence would tell him about those threats, and he would have taken action if he needed to. And also listen to what, the evolution of this. Originally, this was called on the campaign a Muslim ban. Then there was a lot of backlash of that, and that became extreme vetting. Then it became down to these 7 countries. And if you remember, I can't even remember because everything happens every day, but it was either earlier in the week or last week that President Trump said, well, I was thinking about waiting a week or two. I didn't want it to be so chaotic, but my advisors told me, no, we have to do this right away. And you just heard from Jeff Zeleny say that, some of his aides say that it's not so necessary. So, it's creating this kind of fear, and this, reminds me of that movie, Our Brand is Crisis, that there's a crisis happening in this country, and we have to save it we have to save it right away. However, the intelligence from what we're hearing from officials and what the previous administration does, and members of Congress who are seeing the same intelligence, is not adding up.
But that was the campaign strategy. The campaign strategy was you want to get people to your point of view. You stir the pot, you stoke the fear. And I think what you see the president doing is what we're not used to presidents doing. Presidents don't usually stoke fear. What they usually do is try and comfort people and say, we have it under control.
And there is a threat out there. There is a terror threat that the U.S. is facing. Let's not negate that.
But if he's worried about the public opinion about his policy, what he's going to do and what he's doing is saying to people, you need to believe me. I know more than you do. You should be very afraid. And what we're going to do is fix it.
That's good enough for a campaign strategy. It's not good enough for the courts. The courts need to have some concrete evidence, and there's an opportunity you could provide in a classified setting to the court. You can't just do the schoolyard, I know something you don't know, and say, just trust me. What the courts made clear yesterday in the Ninth Circuit was judicial deference is certainly warranted for presidents in terms of national security, but it's not automatic. And more importantly, just a bald assertion of national security is not going to be carte blanche to violate the Constitution. And so, again, you had the President of the United States saying, listen, there is a real and threat, and a credible threat against the United States. Well, the court said, tell us what it is. Give us a reason to reinstate the ban, and he could not.
David, let me read to what the bottom line, what the unanimous decision of the Ninth Circuit Court of Appeals was last night, going against the president on this very sensitive issue. We hold that the government, meaning the U.S. government, has not shown a likelihood of success on the merits of its appeal, nor has it shown that failure to enter a stay would cause irreparable injury, and we therefore deny its emergency motion for a stay. The president made it clear today, we're going to go through the court process. He said, ultimately, I have no doubt we'll win that particular case. It's unclear what he means by that, but this was a major rebuke of the president's travel ban.
Well, it was because the court was pushing back in a couple of areas. One, that they have an opportunity to review it, that the president gets deference on national security, but it doesn't mean that he can't be questioned by the judiciary. And two, what is the specific evidence that requires the executive order? And that has not been forthcoming. Ultimately, the president may indeed be right on the law, which is he may win because the president gets so much deference on national security. But the political realm here, you heard the president talk about, look, there were a lot of people, I'm going to bring jobs back to all these states that voted for me, essentially. Well, he's doing that on the security ban as well. He campaigned on the idea that there's all these bad people overseas and that they're coming to get us. He doesn't have specific evidence for that, but he's making an argument, as are his advisors, that the U.S. is vulnerable like Europe is vulnerable. But that ignores the fact that we have much better safeguards here, particularly for refugees. And he never mentions that point. If you're a Syrian refugee, you can't just get on a plane and come into the country. It takes as long as 2 years.
Yeah.
This is just fear. It's the stoking of fear without any real evidence, and we saw more of it today. And by the way, this also frustration on his part that he has to answer questions about this when it's off topic.
You know, Laura, I just want your analysis. When he says we'll go through the court process, and he predicts ultimately the administration will win, what are the options? What are the next steps?
Well, he could go en banc, which means he could ask more of justices from the Ninth Circuit Court of Appeals to weigh in, as much as 11 others, to say, anyone else feel differently, give him something to work with. Or he could go right to the Supreme Court and say, listen, can you please reinstate this ban under a standard that says they abused her discretion or they were wrong entirely to even suspend it? But either way, we are not at the merits of the case. It's going to go back to Judge Robart in Seattle District Court to say, all right, what are we working with now? Give me a record to develop. Was there an intent to have a Muslim ban? What is your evidence for that? Let me help you develop that particular case. And all we're talking about now is, was there a likelihood of success? Not a guarantee, but you're right, David. There's a lot of deference given to the President of the United States in the national security arena. But our courts and the Supreme Court entirely has often checked that balance, from denying passports to suspected communists to Japanese internment camp victims. And so there is a very marked history where we question any trampling of the Constitution, even national security.
Do we presume the court would take this, given the fact that there isn't much of a history of this case? I mean, or that it's just too important that they would have to take it? There's not much record.
Well, you know, that's in a case, a Supreme Court loves to have a final decision. They want to have everything.
Yes.
A record means I've got all the transcripts, all the testimony, all the evidence, and I'm just reading all the stuff. But the thing is, even though the Ninth Circuit found that there was standing on behalf of Washington and Minnesota to say they've got a real injury to represent the people of their states, the Supreme Court could still take the case and find there was no standing. And the only precedent we have is that we had Texas in the Dreamers case, where they said, you know, think we have standing based on having to provide for driver's license to these Dreamers. Well, the Supreme Court took that case, but unfortunately we had 4-4, which means we don't know what they actually ultimately were considering, and they may have found there was no standing. We're at a disadvantage, which is why the court may be ultimately in his favor.
And I just want to point out that one important line in that 29-page report that the Ninth Circuit Court of Appeals put out: there is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy, because the Justice Department attorney, in making the oral arguments, said that there was no reviewability, if you will. And in this particular case, the court came down on the other side. Everybody hold on for a moment.